Welcome to the Save Our Sperrins campaign, Voices from the Frontline. I'm Morella Fife, your host and a member of the Save Our Sperrins team. At the heart of this struggle are the voices of local people, farmers, families and young campaigners whose homes, work and families are rooted in this place. Their voices are joined by supporters from across the world, standing in solidarity, from professors to artists, from those offering vast expertise to those whose presence alone is an act of support. All have stood with us. In this series, we share stories of resistance, resilience, and hopes from those determined to protect these mountains, their land, their rivers, the very air they breathe, and their community. Let's get started. Today, on the Save Our Sperrins podcast, I'm delighted to welcome Dr Amy Strecker. Amy is an associate professor at the Sutherland School of Law at University College Dublin, where her research focuses on land law, justice and cultural landscapes. She is also a young mother from Dublin, and over the past year she has been one of our volunteer expert witnesses for the public inquiry. We are hugely grateful to Amy for the time, expertise and clarity she has brought to this process. Her keen intellect and her ability to bridge the legal world with the lived reality of people and landscapes has been of enormous help to us as a community. In this conversation, Amy shares her insights on law, justice, and the ways landscapes are understood, not just as places to be used, but as cultural spaces carrying memory, identity and meaning. She helps us see the Sperrins in a wider frame, as part of a global story about land, heritage and the struggle for justice. So let's begin. Good afternoon, Amy, and a very warm welcome to the podcast. We're delighted to have you on here today. Could you start by telling us a little bit about yourself, where you're from, a little bit about your academic path, and what drew you into land justice in the first place?
Well, thanks very much, Marilla. It's lovely to be here. So I'm from Dublin. I live in Kilmacud, Stillorgan, and that's also where I grew up. I lived away for quite a while. I lived in Italy and the Netherlands, and then briefly in Spain and France. So for about 13 years in total, I was away, and came back 5 years ago to Ireland. I have two little girls, and I work in UCD in the law school there. So how I became interested in land justice was, I'd say personally through my dad. My dad was had a huge respect for and understanding of nature, and I suppose he instilled that interest in me, from an early age. And then in terms of my studies, I think it was in my master's that I really became interested in the role of law. I did a master's in UCD in cultural policy, and took a law module, and it was actually 2004. So that was the year of, it was the height of the Celtic Tiger. It was the year of a number of controversies involving heritage sites and road development. And it was also the year that the main heritage law was amended. And so I wrote my master's thesis on that. And it was amended actually to facilitate road development and do away with some of the safeguards that had been enshrined in the law by Michael D. Higgins, because he had done that after the Wood Key case. Anyway, I won't go into the details, but I really became interested in the significance of law and how it can make a difference to a decision so consequential as routing a motorway through somewhere like the Tara Screen landscape. And then after that, I worked for a while, but then I wrote a PhD proposal for the EUI in Florence, which is the European University Institute in Florence, and I was very fortunate and got a Government of Ireland scholarship to do my PhD there in the law school. And I wrote my PhD on the subject of landscape protection in international law, and that kind of came about because there were a number of developments happening at the time, like the adoption of the European Landscape Convention, which was an international treaty that was opened for signature in Florence in the year 2000, and it entered into force in 4 years later. So I was there, I was in Florence around the time that this had just entered into force. And there were also the developments in other areas of international law. So I kind of charted these in my PhD, which I subsequently published as a book. And I was lucky because I was taken on by a professor, Francesco Francioni. He's a well-known international law scholar and practitioner. He was also the chair of the UNESCO mission that went to Kakadu to assess the impact of a uranium mine on the Kakadu National Park, which is a World Heritage Site at the time. And he actually advised against the mine. He said that actually the mine should be, the licenses should be rescinded. The near our people should be granted title, and also that it should be reinscribed as a cultural landscape. And basically it was only recognized for its environmental, its natural features. Anyway, he was a huge influence on me. So, and he kind of viewed cultural heritage as not separate from human rights and the environment. So I think that he was a huge influence as well. And then after my PhD, I worked for a while. I was actually a secondary school teacher in Ireland for a few years.
All right.
So, I went back into academia then. I took up a postdoc position in the Netherlands in Leiden University, and I was involved in a project that was assessing the impact of colonialism, basically colonial encounters on the Caribbean. So I really started researching land rights issues and Indigenous people's rights and cultural revival. And I analysed how international law was being used by communities in the Caribbean to agitate for their land rights and also for restitution and repatriation. So I suppose my interest kind of went from being heritage protection to landscape to being broadening out to land rights. And then, and now I see these things as being interrelated,
Right.
But yeah, but I suppose I've become increasingly preoccupied with more social justice issues related to landscape. And aside from academic work, I've always tried to be involved as much as I can in like the policy side of things or the advocacy side of things.
Right. Okay. Yeah. Okay. That's fascinating because when you said your dad was your initial influence and you came in maybe from an environmental angle, but you end up in law. And I wondered, as I was preparing for this interview, I wondered, was it because of an influence of law, but it was an influence of the environment? So it's kind of interesting around that. Just because we have an international audience listen to us, can you say 2 lines about the Tara Screen landscape and about what the Wood Quay site is? Because it's familiar to us in Ireland, but anywhere else people wouldn't be familiar. And then could you tell me what happened, what was the outcome of the Kakadu National Park? If you could just clarify those little points for me, that'd be great.
Sure, Morella, sorry. Yes, so the Wood Quay was it's a Viking site in Dublin on the banks of the Liffey, and actually it was one of the most extensive Viking sites ever found in Europe. So it was essentially the early city of Dublin, and Dublin Corporation, now Dublin City Council, approved the building of their new civic offices on the site of Wood Quay. So it was the first major heritage controversy in the state, let's say, and it was a huge march. Turned out about 20,000 people, which was the largest since independence, walked through the streets of Dublin in opposition to the development of the offices on the Wood Quay site. There was a lock-in. Anyway, so but this case is often referred to as one of the early heritage disputes in a long line of heritage disputes that we have. And then the Tara Screen Valley was a decision taken in August 2003 by An Bord Pleanála, the Irish Planning Board, to approve a motorway route, the M3 motorway through the Tara Screen Valley. And there had been a number of route selection options, and the route that was ultimately selected was quite problematic from a heritage standpoint. And the archaeologists who had worked on Tara on the discovery program, which was funded by the state, opposed the routing of it. But also there was popular opposition, and again there was a march through through Dublin. I took part in the march, and there was a High Court case taken by an applicant, Vincent Shalafia. He lost the case, and actually he lost the case on the grounds that he didn't have, one of the grounds that was that he didn't have sufficient interest in the case because he wasn't a landowner in the vicinity
Oh,
of the motorway, which I found quite interesting. Um, yes, so those two Woodkey and Tara, they're infamous planning decisions
sure.
that led to the sort of the destruction of heritage sites in Ireland. Um, and then the Kakadu, the uranium mine wasn't approved. So the mission was
Okay.
successful in a way. So the mine wasn't approved. Um, yeah.
That's great, Amy. You've really opened up what land and law mean beyond the textbooks when the rubber hits the mat. I remember, and I was in secondary school in Dublin years ago. We had what we thought was a loopy English teacher who was forever out on marches saving George in Dublin because all the Georgian squares were being pulled down here. I'm talking about the early 70s at the stage, you know. And we did not know what she was on about because we thought they're only broken down old buildings, you know. And now I'm very aware of it, but back then we just didn't. And she was a wonderful teacher and she used to weave George and Dublin through all her poetry and so on, you know. But yeah, how times have changed. So if we take some of these ideas, let's look what it means for the Sperrins. From your perspective as a researcher in Dublin, what makes the Sperrins case stand out as an example of land injustice?
Well, I think in the broad scheme of things, if we look at the Sperrins in relation to other forms of land injustice globally, let's say, or internationally, um, it doesn't stand out in one way because the playbook is the same. And I'm talking about the playbook, the mining companies have the same playbook.
Uh-huh. Yeah.
And that's very visible in the Sperrins. I mean, an attempt to diminish the special nature of the landscape, the divide and rule, sort of divide the community, promise the world, all of these things. But I think it's unique on this island, definitely. I mean, for me, it's the greatest substantive landscape injustice currently taking place in the island, or potential landscape injustice that hasn't been approved yet, and that's thanks to Save, a great part to Save Our Sperrins. But I do think it's unique on this island. Yes, I think it's. I mean, we've never had an application like this of this magnitude to date on the island. Yeah, in such a sensitive area.
Okay. And when you compare what's happening here to other places you've studied, are there similar patterns of land being treated as just a commodity rather than a living landscape?
Yes, I think absolutely. So when I worked at Leiden University, I was involved in organising these annual colloquia with my Indigenous colleagues, and so it was heritage and rights of Indigenous peoples, and it was really organised around the themes of sovereignty, land, and culture, and a lot of the problems raised in these colloquia related to extractive industries and large scale development that didn't really have democratic legitimacy, but also were hugely devastating for environmental, for the degradation and landscape degradation, environmental degradation, and also broken social relations that they caused. So I think what's happening, or what has happened to date in just the application stage, is very similar to some of the cases that I would have heard about and also studied in my own research in elsewhere.
Right.
Yeah.
Okay. Amy, how does international or European law come into play? Are there opportunities for communities like ours to seek protection beyond our local planning systems?
So there are, so there's a number of relevant international law.
Okay.
The problem is sometimes its enforceability, or its enforceability in particular jurisdictions. So it's not the absence of binding international law norms because we do have several. I don't know if you'd like me to just go over what there is that's relevant in this case.
If it would be helpful, because there
Yeah.
will be others in similar situations in the future, and
Mhm.
this would be a good reminder around that.
So, so at the international level, there's been a development in procedural environmental rights, and I suppose here we have the Aarhus Convention. The Aarhus Convention is a binding international treaty, and it's on access to information, public participation, and access to justice in environmental matters. It was also incorporated into EU law. Now, I know that's a bit more complicated now after Brexit. But there are still binding provisions that were already incorporated into domestic law, so they are
Mhm.
relevant. And they were, I think, they were brought up in the public inquiry as well. So there's been problems with procedural environmental rights, and that is something that can be uh, brought up again at a later date. I
Yeah.
mean, it's a very serious legal issue. I think there has been quite a lot of procedural problems in the application in the process to date. There's also the European Landscape Convention, which is often forgotten about, but it is a binding treaty. And
Okay.
that the Landscape Convention is a Council of Europe treaty. And of course, the UK and Northern Ireland is still part of the Council of Europe, if not the EU. That treaty is about public participation in landscape planning, and it's linked to Aarhus, but it's not a human rights treaty. It's more about acknowledging the fact that landscape is essential for well-being and for identity and for people's sense of place, and it highlights principles like subsidiarity, which is the idea that planning decisions should be made by the local authority, the most local authority, and that people ought to be involved in the planning decisions affecting their landscapes.
Yeah.
Um, so
Sorry, just before you leave that one, what was the title of that one here? I'm just writing it down for my own
it's originally called the European Landscape Convention, and they've officially changed the title now to the Council of Europe Landscape Convention.
Europe landscape. I got the Council of Europe, but
Council of Europe Landscape Convention. Yeah.
okay.
And that establishes particular obligations on states. So it provides for, it says, this public authorities need to provide for the active participation of people in landscape plans and policies.
All right.
So it's very much democratizing landscape in
Okay.
that way. Hmm.
Okay. Oh yeah. Well, maybe we should check that one out a little bit more thoroughly.
Um,
We'll see what happens.
yeah,
Is there
yeah.
any more?
And then there's the human rights. I mean, there's been huge development in various human rights. I mean, if we look at, the development of the idea of a right to a healthy environment, we have developments in cultural rights, and there's two different cultural rights. There's the right to participate in cultural life, and that has broadened out to mean not just, to participate in the arts, but also to have access to those environments that are important for cultural identity, as well as the right to one's own culture, which is in the International Covenant on Civil and Political Rights. That's Article 27. And traditionally that has meant the right to culture, especially for Indigenous peoples, and their rights relating to natural resources and customary rights. But that's broadened out again in recent years. It's been extended to other communities as well. So it's really an acknowledgement that culture includes the way of life relating to a particular place. Um, there's, there's an emerging rights of nature movement as well, and that's been used already in several jurisdictions to refuse planning permission to large mining projects that would have a detrimental impact on certain species and habitats. There was a recent case, Los Cedros in Ecuador, which involved a refusal of a mining project because it would harm the Los Cedros forest and the species that live in the forest. So There are a number of developments, but I suppose the ones I'm interested in are really related to the rights, procedural rights, substantive rights, and also the developments made in cultural heritage law, which is I teach at UCD. And cultural heritage law, international cultural heritage law, has developed quite significantly in the last 2 decades. So we have the idea of cultural landscapes being incorporated into the World Heritage Convention now.
Okay.
And we also have the Intangible Cultural Heritage Convention, which was
Hmm.
adopted in 2003. And that really broadens this idea of cultural heritage out beyond just monuments or physical sites to also include intangible cultural heritage and basically the associative aspects of heritage. And that can include anything from from folklore to customs to beliefs and all of those sort of more than material things, the immaterial, the relationships that people have.
That brings us actually quite neatly to the next layer of the story, we might say. You're just chatting there about cultural heritage. Can you explain exactly what that means and why the Sperrins might be understood as a cultural heritage landscape?
Sure. So the term cultural landscape itself is quite a broad one, and it's used in many different ways. When we're talking about it in relation to heritage sites, often that means World Heritage cultural landscapes,
Okay.
even though cultural landscapes can be beyond World Heritage.
Yeah.
So in the World Heritage Convention, cultural landscapes are defined in 3 different ways. I think 2 of those ways are relevant for the Sperrins. That's the associative cultural landscape. So it's basically a place that has very strong associations for the people who live there.
Yeah.
And then the second is relict or fossil landscapes, and that's landscapes where you have a lot of archaeological heritage sites, and that's also the case because you have the Begmore stone circles, you have a lot of archaeological material remnants in the landscape
Yeah.
that tell you about its past. And then there is a third category, but I don't think it's relevant in the case of the Sperrins. But really, broadly, a cultural landscape really just refers to um, a landscape where you have very strong relations between people and the physical environment, and that's visible. Yeah.
So sort of cover history, story, tradition.
It can also cover agricultural landscapes as well. And I suppose
Okay.
there's an emphasis on sustainability.
So can you tell me what happens when the cultural meaning of a landscape clashes with an extractive project such as a gold mine?
Do you mean what happens usually or what ought to happen?
What happens you well, let's take the two. Let's give it a description of what happens usually, and then if you were given free reign in the world and you were made a dictator to the day, what ought to happen?
Well, what happens usually is it depends. I suppose it depends on where. It depends on the context. It depends on where we're talking about. It depends on whose land or whose territory, where the application is being,
Coming from.
um, yeah, where the project is proposed, and that depends. So more often than not, um, it's human rights law that more often than not, it's the state that's facilitating these industries, and it's up and more often than not, it's the communities that are doing the real work in opposing the projects on very legitimate grounds, but also even I would say doing the work that the public authorities should be doing. I see
Uh-huh.
that very clearly in the case of Save Our Sperrins. Actually, what SOS is doing is actually what as the job ought to be the job of the public authorities, because they're upholding all of these agreements that the state has made but isn't really paying any attention to.
Right.
So that's what usually happens. And then usually then there's a case at a later stage, whether that's a human rights case or some kind of a judicial review at national level. And inevitably, the decision will be looked upon retroactively as a very poor planning decision, contrary to a whole host of, environmental law norms and human rights norms. But that's that's with hindsight.
Yeah.
And then what ought to happen, of course, is that the state really should be applying all of the obligations it has agreed to in the process of assessing a potential application like the gold mine, and weighing it up at an earlier stage. I mean, for me, I find it very hard to believe that it's even got to the stage of consideration that it has. I mean, if all of the obligations relating to the Sperrins had been taken on board at an early stage, it would never have got to this stage in the first place, you know.
Well, I have to say, we would agree with you totally. And Save Our Sperrins, the work we're doing feels like we should be our own government department. And when I laugh because it's all done on a shoestring budget, but yeah, it's we'll keep at it and we'll keep doing it, and hopefully we'll make progress on the way. So that's really a rich way of looking at the Sperrins through cultural landscape. If you could redesign land law so it genuinely delivered justice for people, for communities and nature, what would be one change you would like to make?
Well, I suppose when I think of land law, I think of, land law is dominated by property, by the concept of property, but also property rights. And my colleague Amanda Beyer has written a great book called Placing Property, and she analyzes the historical origins of property. She kind of provides a legal geography of property, and property is really just, it basically made land and relations to land very abstract, because property relates to rights to use and alienate and exclude people from land. But
Okay.
there's a lack of responsibility there in relation to the uses of that land, the limits of particular places, the conditions of particular landscapes. So there's a real emphasis on individual rights rather than responsibilities, but also it's more, property is so narrow. It's so it's such a diminished way of
Reductionist, even.
exactly. And I personally, I don't really work on land law per se, because land law deals with a lot of property rights issues and tenancies and landlords and all that kind of mortgages. You know, I'm more interested in what I would term landscape law, which incorporates broader areas of law that relate to land use. So environmental law, cultural heritage law, human rights law, planning law, and even some areas of trade investment law that impact land use. So when we think of land and the decisions made over how to use our land, they all come from different areas of law. And I suppose planning law is the area of law that regulates, or that sort of, it places limitations both on citizens, but it also it's that area of law where I think the state has the most discretion, and I think that's problematic.
If I could get in there, do you see law as something that protects communities and landscapes, or more often something that leaves them vulnerable?
I would say, unfortunately, it depends. It depends on, for major projects, I think it's definitely the latter. So it's definitely, it doesn't work in the favor of communities, because there's so many vested interests in these huge major projects that often communities are left behind, or at least they're not considered, whereas they should be the central and first point of contact, point of reference. But it depends, I suppose, on the type of development. But in this case, let's say we're talking about an extractive project. I think, yes, I think too often the decision is made way, far away from the communities. I mean, like even in the case of the gold mine, it's the Department for the Economy that issues the licenses.
Mm-hmm.
Then it's the Department for Infrastructure, not the local authority, which would be for Manningham District Council. And it should be the local authority, because they know the landscape, they care for it, they're representing their people. You know, when things are so far removed and abstract, I think it leads to all forms of spatial injustice. I don't know if that answers your question.
It does really well. I'm mulling over something here. Going forward, do you see heritage law and environmental law working together, or are they too often kept apart?
I think they're too often kept apart. I think in international law that's slowly changing, because you have the landscape and the landscape convention, which brings the two together.
Mm-hmm.
And you have the cultural landscapes concept, which acknowledges the human dimension to nature and the symbiotic relationship. But unfortunately, in national law and in the planning process and environmental impact assessment, they're often kept very separate. So in an EIA process, you have, cultural heritage, which now includes intangible cultural heritage, but which unfortunately is still sometimes perceived as being just the material cultural heritage, like archaeological heritage or architectural heritage. And then, the natural aspects again are separated, into species and habitats and air and soil and all of these things, when actually they're often related. So yes, there's still a separation in EIA. Of course, the community consultation piece should really fill the gaps. But again, that's not taken seriously enough, even though it's an obligation.
Yeah.
If there was true participation, that would be an opportunity for local people to fill in those gaps.
Yeah. From our experience, community consultation just turned out to be a PR and marketing exercise for the company, nothing more.
Completely, yeah.
Just laughable.
That's a violation of the Aarhus Convention because, in order for there to be participation, there has to be access to proper information, and access to information about the nature of the project was not fully available from the onset. So yeah,
absolutely wasn't. Amy, we're coming towards the end of our chat here this afternoon. I know you have some books published. Can you tell me a little bit about your book and where, well, if you give me the website, I'll put it in the show notes afterwards, or where people could get it. And you also mentioned your friend there, Amanda Breyer. If you could mention her book again as well, for people listening to this, it'd be really good.
Sure. So Amanda's book is it's Amanda Breyer, Placing Property: A Legal Geography of Property Rights in Land, and it's published by Palgrave Macmillan, and that was 2 years ago, I think now, and it really gives an excellent overview of property rights in land, and why they're problematic. And then my own book is Landscape Protection in International Law, and that's published by Oxford University Press in 2018. And I'll send you links for both of those. Yeah.
Okay, that's great.
But they I suppose both of them give an overview of how land is considered in law, both common law, but also international law.
Okay, great. That's great. And it'll be in the show notes when you send them up to me. Before we finish, I have two questions I now ask everyone, which one of them you'll be expecting, but the other one you won't. So can you recommend someone who you think we should invite onto this podcast?
I suppose Sinead Mercier, I would like to recommend. Yes, absolutely.
Okay. And can you just say one or two lines about Sinead?
Well, she's a colleague of mine on a research project we have at UCD on land, property, and spatial justice. She's an activist herself, as well as a researcher, and she's a very inspiring person. And she actually was the person who first told me about the Sperrins. And then I introduced me to the work of Vicenza. And yeah, I think she would be great to have on. She's been following the Sperrins for years, and also I think she worked as a parliamentary assistant years ago and arranged a visit, I think, to the Dáil to meet with Eamon Ryan when he was,
Okay.
Yeah.
I'll check her. I'll get, maybe you send me her contact details as well. That would be really helpful. And of course, the last one, which we ask everyone, is what gives you hope, either in the Sperrins or in your wider research? What gives you hope?
I suppose what gives me hope in the Sperrins is with the campaign itself. I mean, it's such an impressive campaign. I became involved much later on in the campaign, but it's 10 years going, and I think, as I mentioned, I think that you're doing the job that the public authorities should be doing, but you're doing it very effectively and on a shoestring compared to the resources that at the disposal of the mining company. And I think that's really impressive. And that gives hope, and also the networking and solidarity with other groups. What gives me hope beyond that, I suppose, is that, for all the injustice that we have and all the terrible legal norms that are, engendering injustice, we also have other areas of progressive development in the law, and I think we have to nurture them and sort of make them more visible. And they're the result of bottom-up organizing, like things like rights of nature, and the agitation on the part of communities, like for UNDROP, the UN Declaration on the Rights of Peasants, or UNDRIP, the UN Declaration on the Rights of Indigenous Peoples. All of these progressive developments, they actually came out of bottom-up processes. And it shows you that, it might seem counterintuitive because they're international law and international law is further away from the citizen, but at the same time, they're the result of states not representing their citizens properly and or communities seeing international law as a potential area for lawmaking or placing pressure, international political pressure on states. So I think those developments are really promising. And so I think, we have to keep pushing them forward.
Yeah, from the grassroots.
Yes.
Dr. Amy Strecker, thank you. Thank you for all the academic work you're doing and your support, particularly with our public inquiry. Thank you for your deep concern around our general environment, both locally and in the greater world. And thank you for your care for community and heritage. And I have to say, without you, the Sperrins campaign would be a poor campaign, and we are so grateful that you have taken the time to get involved with this campaign. It means so much to us, and we look forward to working with you in the future.
Well, it's an honour, Mirella. Thank you very much.
My thanks again to Dr. Amy Strecker for joining us on the podcast. Amy has given so generously of her time and expertise as a volunteer expert witness for the public inquiry, and we are deeply appreciative of the clarity and commitment she has brought to the campaign. Her work helps us understand the Sperrins not just as a place under threat, but as a living cultural landscape that deserves protection. We're very grateful to have her standing with us. You've been listening to the Save Our Sperrins podcast, Voices from the Frontline. Thank you for joining us today. All the links you'll need, from campaign updates to our social media pages, as well as links shared by today's guests and resources mentioned in the conversation, are available in the show notes. Please take a moment to share this podcast with friends, neighbours, or anyone who cares about protecting our land and communities. And don't forget to hit the follow button on your podcast platform. It really helps the algorithm spread these voices further. Together, our voices are stronger. Thanks for listening, and until next time, keep standing with the land, the water, the air, and the people who protect them.